Privacy is a fundamental human right. In the workplace, privacy becomes even more critical. Employees deserve to feel safe and secure. Their personal lives should be respected. The Bill of Rights forms the basis for privacy protections. These amendments establish principles that protect individuals from government intrusion. This foundation extends to the workplace, where individuals deserve freedom from unreasonable surveillance. The digital age presents new challenges to workplace privacy. The rise of remote work, social media, and surveillance technologies have created new avenues for potential privacy violations. Employers have access to vast amounts of employee data, from emails to biometric information. This data can be used for legitimate business purposes, such as monitoring productivity and ensuring security. However, it also raises concerns about misuse and the potential for discrimination. The concept of workplace privacy encompasses a wide range of issues, from the confidentiality of personal information to the protection of employee communications. It includes the right to be free from unreasonable searches and seizures and the right to control one's personal data. Employers have legitimate interests in monitoring employee activity to ensure compliance with company policies. However, it is essential to strike a balance and ensure that employee privacy rights are not unduly infringed upon. Balancing employer and employee rights is a delicate act. Employers need to protect their businesses. They have a responsibility to their shareholders. They also have a duty to maintain a safe and productive work environment. This includes protecting company assets and ensuring compliance with regulations. Employee rights, however, must also be respected. Employees deserve a degree of privacy and autonomy in the workplace. The challenge lies in finding a middle ground. Transparency is key. Employers should be upfront about their data collection and monitoring practices. Informing employees about what information is being collected and how it will be used can help build trust. Proportionality is also important. Monitoring measures should be proportionate to the legitimate business interests being pursued. For example, monitoring employee emails to ensure compliance with company policies is reasonable. However, tracking employees' every keystroke or monitoring their personal social media accounts would be excessive. The level of surveillance should be appropriate to the risk being addressed and should not unduly infringe on employee privacy rights. Federal laws regarding employee privacy are a patchwork. There isn't one comprehensive law. Instead, there are several laws that address specific aspects of employee privacy. These laws often have loopholes and limitations. The Electronic Communications Privacy Act, or ECPA, addresses electronic communications. It covers emails, phone calls, and other forms of electronic communication. However, it has exceptions for employer-provided networks, allowing employers to monitor employee communications on their systems. The Health Insurance Portability and Accountability Act protects health information. It applies to healthcare providers and health plans, as well as certain employers who handle employee health information. This act requires employers to safeguard employee health information from unauthorized access and disclosure. Other laws, like the Employee Polygraph Protection Act and the Fair Credit Reporting Act, address specific issues. These laws provide some protection, but they don't create a comprehensive framework for employee privacy. Workplace surveillance takes many forms. Employers use various methods to monitor employee activity. These methods can range from simple observation to sophisticated electronic surveillance. Email monitoring is common. Employers often monitor employee emails sent through company servers. They may also monitor emails sent from personal accounts if accessed on company devices or networks. This monitoring can be justified for legitimate business purposes, such as preventing harassment or protecting trade secrets. Video surveillance is another common method. Cameras are often used to monitor workplaces for security purposes. They can deter theft and vandalism and monitor employee behavior. However, video surveillance can be intrusive and create a sense of being constantly watched. Keystroke logging and internet usage tracking are more intrusive forms of surveillance. Keystroke logging records every keystroke an employee makes. Internet usage tracking monitors websites visited and online activity. These methods can provide detailed information about employee behavior, but can also be seen as overly invasive. Social media monitoring. Social media monitoring is a controversial topic. Employers are increasingly interested in monitoring employees' social media activity. They want to protect their reputation and prevent leaks of confidential information. However, social media monitoring raises ethical and legal questions. It can blur the lines between personal and professional lives. Some employers use social media screening during the hiring process. They review applicants' social media profiles to assess their character and suitability for the job. This practice can be discriminatory and reveal personal information irrelevant to job qualifications. Monitoring employee social media activity after hiring is also controversial. Employers may monitor public posts for signs of misconduct or policy violations. The American Privacy Rights Act, or APRA. The American Privacy Rights Act is proposed legislation. It aims to create a comprehensive federal privacy law. It would preempt state laws and establish a uniform standard for data privacy. Currently, APRA does not specifically address employee data. However, future amendments could extend its reach to the workplace. APRA's potential impact on workplace privacy is significant. It could establish clear rules for data collection, use, and disclosure. It could also provide individuals with greater control over their personal data. State privacy laws. State privacy laws vary widely. There is no uniform standard for employee privacy across the United States. Some states have strong privacy protections, while others have weaker laws. This patchwork of laws creates confusion for employers and employees alike. California is a leader in employee privacy. The California Consumer Privacy Act, or CCPA, provides broad privacy rights to California residents. While CCPA primarily focuses on consumer data, some provisions may apply to employee data. Other states, such as Illinois and Virginia, have also enacted comprehensive privacy laws. These laws provide varying levels of protection for employee data. The lack of a federal standard creates challenges for businesses that operate in multiple states. The future of employee privacy. The future of employee privacy is uncertain. Technology is rapidly evolving, creating new challenges for protecting employee privacy. One key challenge is the increasing use of artificial intelligence, or AI, in the workplace. AI can be used to analyze vast amounts of employee data and make predictions about employee behavior. This can be used for legitimate business purposes, such as improving productivity and preventing fraud. However, it can also raise privacy concerns. Another challenge is the rise of the gig economy. Gig workers often lack the same privacy protections as traditional employees. Despite these challenges, there are also reasons for optimism. The growing awareness of privacy issues is driving demand for stronger protections. Employees are increasingly demanding greater control over their personal data. The role of technology. Technology plays a dual role in employee privacy. It can be both a threat and a solution. Surveillance technologies such as facial recognition and location tracking can be intrusive. They can be used to monitor employee movements and activities in unprecedented detail. Data analytics and AI can be used to analyze vast amounts of employee data. This can reveal sensitive information about employees' personal lives and preferences. However, technology can also be used to protect privacy. Privacy-enhancing technologies such as encryption and anonymization can help safeguard employee data. Advocacy and awareness. Advocacy and awareness are crucial for protecting employee privacy. Employees need to understand their rights. They need to know what information is being collected about them and how it is being used. Employers also have a role to play. They should be transparent about their data collection and monitoring practices. Organizations such as the American Civil Liberties Union, or ACLU, and the Electronic Privacy Information Center, or EPIC, are advocating for stronger privacy protections. These organizations are working to raise public awareness about privacy issues. Education and training are also important. Protecting privacy in the digital age. Protecting employee privacy in the digital age is a complex challenge. It requires a balancing act between employer interests and employee rights. Federal and state laws provide a patchwork of protections. These laws are often outdated and inadequate to address the challenges of the digital age. A comprehensive federal privacy law is needed to establish a uniform standard for employee privacy. Technology can be both a threat and a solution. Surveillance technologies can be intrusive, but privacy-enhancing technologies can help safeguard employee data. Advocacy and awareness are essential. Employees need to understand their rights and how to protect themselves.